Good morning, everyone. Thanks for joining us for Business Series. We have lots of guests in the waiting room, so we're going to give them just a moment to join before we get started. So grab a refill on your coffee and we'll get started in a moment. Okay, looks like we have a few people still joining us, but a great group this morning. So let's go ahead and get started. So welcome everyone to the July Business Series. My name is Elaine Bonneau with Downtown Inc. I am really excited to be with you this morning to present some information that I think you're going to find very valuable. I've had lots of conversations about this with some of you and many business owners downtown. So we're excited to bring this information to you today. We're going to be talking about copyrights and trademarks. But before we get into that, I just want to share a couple of things with you so that you can get the most out of this experience. If you have questions about anything that we discussed today, please feel free to drop your question in the Q&A, in the taskbar, or in chat if you just have comments or want to discuss something further, and we'll make sure that we address your questions and comments during the presentation, and we'll save time at the end, probably about 10 minutes to address any questions that you have. Unfortunately, with the size of the group, we won't be able to do live Q&A, but we'll make sure that any questions you put in Q&A or in chat that we address them. Also, if you're experiencing any issues hearing the webinar, you can try dialing in through one of the telephone lines that was in the registration confirmation email you received. But if you miss anything, the replay will be available later this afternoon. So look for an email later from Downtown Inc. and there will be a link in there that takes you to the downtownyorkpa.com website, and you'll be able to see the entire replay from today. So before we get into today's discussion, I just want to thank PNC again. PNC is our presenting sponsor for the Business Series workshops this year. We're so happy to have them as a continuing partner. And Greg Verbowski is the Vice President, Branch and Business Center Manager for PNC. He's joining us this morning and just wanted to say a few words to welcome everyone. Good morning, Greg. Good to see you again.
Good morning, Elaine. Thank you very much. Just, obviously on behalf of PNC, the 3 branches that are in York, we're happy to be the presenting sponsor. As always, looking forward to really been curious about without doing any of my own knowledge. So again, happy to present, proud to be a partner with Downtown Inc. and love to see what we're going to talk about today. Thank you.
Yes, and thank you, Greg. It's going to be a great topic. And just to share with you and everyone else on the call, the reason that we decided to add copyrights and trademarks to the calendar of topics this year. And so, this calendar is developed by what you want to hear about. So as we get further into the end of the summer, early fall, we'll reach out to you and say, hey, what's on your mind? What is it you'd like for us to discuss in 2022 as we're planning the calendar? But for today's topic, I don't need to tell you that York is a very creative community, right? Whether you're an artist, metal worker, or maybe you've just developed, a unique business model with a logo and a brand that identifies your business. You want to share that, right? You, as an artist, you want to, and a creative, share that with the community. But there's also a need to protect that and protect that legacy. And, oftentimes I get asked, how do I copyright my intellectual property? Where to begin, and then how to protect it down the line. So today we invited Kate Hynes to talk to you about just that. And I want to share a little bit about Kate Hynes and also personally. So bear with me just a moment while I gloat about you, Kate. Kate Hynes is an attorney and partner with Stock and Leader Attorneys at Law. Kate is a member of the firm's business and real estate practice groups, focusing her practice in the areas of business and commercial transactions, intellectual property, business planning, and commercial real estate and finance. Kate is a native of Brookville, Pennsylvania. She received her BS magna cum laude from Drexel University in 2010. In addition to academics, and I have to throw this in here because we're all getting ready for the Olympics now, Kate excelled athletically as a member of the varsity diving team and was recognized in 2008 and 2009 with honorable mention All-American status for her performance at NCAA Division I Nationals. In 2009, she was named an academic All-American by ESPN magazine. And in 2010, she was recognized as one of the 25 most influential athletes in 25 years by the Colonial Athletic Association. Kate was admitted to the Pennsylvania Bar in 2013 after earning her Juris Doctorate from the Dickinson School of Law of Pennsylvania State University. During law school, she served as a senior editor for the Penn State Journal of Law and International Affairs. And prior to law school, Kate interned as a financial analyst with JP Morgan and Chase Company. Okay, so that was a mouthful. I'm winded saying it. In summary, let me just summarize all of that for you. Kate is a badass chica in charge. And whether it's sports or legal, you'll be glad to have her on your team. And personally, I will say I'm glad to have Kate on our team. Kate is our vice chair for the York Business Improvement District Authority Board for Downtown Inc. And so, Kate, I just want to say I appreciate having you as a resource and just your expert advice on an ongoing basis, personally and from an organization level. So thank you for joining us for this really important topic. And with that, I'm going to turn it over to Kate.
All right, well, thank you, Elaine. I'm a little bit sweet. I haven't thought about my old athletic career in quite some time, but thank you for sharing all of that. So I'm going to go ahead and share my screen. Bring up PowerPoint. All right. So I presume everybody can see that. I'm sure Elaine will stop me if you can't. As Elaine said, I'm Kate Hynes with Stock and Leader, and we're going to talk about copyrights and trademarks today. This is probably my favorite area of law that I practice. It's really interesting, and I hope you guys find it interesting as well. As she said, feel free to drop questions in the chat. I'll be happy to answer any of them to the best of my ability. And so we'll get started. So we're going to start with copyrights. What is a copyright? And I can tell you, even in the legal office, people get trademarks, copyrights, patents confused. So we're going to start with simple definitions. A copyright is the exclusive legal right given to an originator or an assignee to print, publish, perform, film, or record literary, artistic, or musical material and authorize others to do the same. So what the heck does that mean? Essentially, a copyright protects an original work of authorship that has been fixed to a tangible medium. So when pen is to paper or brush to canvas, code to computer, that is when the copyright attaches. I have here listed some common works of authorship: literary, musical, dramatic, motion pictures, sound recordings. As I noted, the coding is one of those. One that is not listed that is becoming increasingly more important every year is software. Software code is considered copyrightable, as are databases. So unique databases of information can be copyrighted. So importantly, a copyright does not protect the underlying ideas, only the expression of the idea. So I often have folks that come to me and say, I have this great idea, I have this process, this way of doing things, and I want to copyright it. That isn't really the function of a copyright. You could potentially copyright the manuals discussing an idea or other expressions of that idea, but somebody taking your process is not under copyright. That is likely what's under called trade secret. And a trade secret, don't have a lot of time to go into it today, but it's basically you can have a legal protection of a secret as long as you make efforts to maintain secrecy. So kind of famous examples of that would be the Coca-Cola recipe is considered in some degree a trade secret. So on this slide, I have examples of things that are not considered copyright. So an abstract of a story, not necessarily copyrightable, but the written story is. And finally, this is a huge question. Do I have to register in order to have a copyright? By register, I mean with the federal government. The answer is no. The moment I said you put pen to paper, you have a copyright. You also don't need to identify with that little C that you have a copyright. It automatically exists. So the question then becomes, well, why the heck would I register then? Why would I spend the money on filing fees, maybe legal fees if you get a lawyer involved to assist you with the registration? And there are a variety of reasons, but I'm going to hit on two major ones. The first is to make your copyright a matter of public record. So there is a record indicating when you registered, when it was published, so the world knows, you know, Mr. Smith has a copyright on this material. So if someone comes out of the woodwork later copying it, there is no legal dispute as to who was the originator of that work. And from my perspective as a lawyer, if you register with the federal government, a copyright, you can have access to statutory damages and attorney fees if you are successful in litigating your copyright. So if someone is infringing your work and you sue them, you can collect set statutory damages, and I don't know them off the top of my head, but they're significant, and attorney's fees. If you don't have a registration and you want to try to enforce your rights, you have to prove damages, meaning you have to show how you were harmed monetarily, which can, particularly for artistic works, can be very difficult. So examples of damages, you'd have to show that you had licensed your work for a specific fee in the past, or had sold your work for a certain dollar figure and you had lost profits as a result of that. That can be very difficult depending on the nature of the work. So the ability to obtain statutory damages, meaning you don't have to prove how you were damaged, you don't have to prove by how much, can be extremely valuable. Another question I often get is, you know, when should I register? And likely when the best time is when the work is completed. Because if there are modifications, those modifications are not captured within your copyright. And to kind of follow up on that, folks often ask, okay, well, you know, let's use software as an example. This comes up. You know, I have a piece of software. Obviously, there are updates, particularly with that type of a work. Do I need to keep re-registering this copyright? And unfortunately, the answer is yes. So oftentimes what people will do is they will wait until there are significant modifications to justify an update to the registration. If there are minor modifications, they might leave it alone. Okay, so back to exactly what a copyright is. It's what's considered a negative right, meaning you can keep others from using your work in a certain way. So you have the right to exclude others from reproducing the work, making reproductions that are substantially similar. So someone can't say, oh, well, I changed, you know, just a little bit. Kind of the thing that comes to my mind, because I'm a huge David Bowie fan. When Vanilla Ice tried to take the chorus of Under Pressure, and he just changed it by a ding. Maybe I'm aging myself, that he was trying to make that argument. That doesn't fly. He was using it in a substantially similar way. Distributing the work or things, substantially similar to the work to the public. Creating a derivative work. This essentially means think of a sequel to a book or a movie, something like that. You can stop others from performing the work in public, displaying the work in public, or transmitting the work by means of digital audio transmission. Another big question, how long does it last? So if there is one author, an individual person, a copyright will last for that person's entire life, plus 70 years. If there's more than one author, it will last the life of the last surviving author, plus 70 years. And there's another category, anonymous works or works made for hire, and we're going to discuss that in a minute. The copyright will last 95 years from publication or 120 years from creation, whichever is first. So if you're thinking about using something that is considered public domain, so that's what happens after the copyright runs out. A work will become part of the public domain and it is free for use. My partner is on this call, and I often, ruin movies because, folks will be watching TV. Inevitably, they'll be watching something that's, extremely old or whatnot. And, I think often it's probably because that, potentially could be in the public domain at this point. So, all right. This is a big one. Who actually owns a copyright? And particularly for entrepreneurs, this is essential. So first, let's talk about joint copyright holders, excuse me. So example of a joint work. Let's think of a comic. If you have someone that's writing the storyline and someone that's preparing the art, they each hold part of that copyright together. Even if, one commissioned the other. Works made for hire. I referenced this earlier. This is a legal term and has a specific meaning by statute. And essentially, if you are hired, and by hired, I mean a W-2 employee hired to do work to create certain things, your employer will own that work. You were hired to do the work, and therefore, as a matter of law, that work is owned by your employer. So where this gets complicated is the next one, independent contractor arrangements. And this is kind of a trap for entrepreneurs. The work made for hire arrangement doesn't work for independent contractors. By law, there is a very narrow set of things when you hire somebody to create it for you that will automatically transfer to you. So that means, for example, you hire a graphic artist to prepare a logo for your business. You pay them, they're a 1099 independent contractor. You pay them, I don't know, $1,000 to prepare this logo. You use the logo. You move along thinking, hey, I own this. And legally, you do not hold the copyright. The independent contractor that created that work holds the copyright. Essentially, what will happen kind of in the back end, if no written documents are created, is that you've been essentially granted a license to use the copyrighted work that the artist holds. So how do you get around that? You say, I paid this person. I don't want them to come back and have rights in, my business logo or to have any claims to that. And the answer is by contract. And generally the language of the contract can be kind of complex. You have to identify, that the work will be assigned over by the independent contractor, that they will agree to do all of those things. But if you don't have a writing which identifies all of those things, there is a very good chance that the independent contractor could come back and have some claims to the work. Finally, licensing arrangements. So I kind of referenced this just a minute ago. When you have a copyright, when you have created something, you have the ability to license it, and you can license that. You can allow others to use it without giving away your entire copyright. So that can be done on an exclusive basis. It can be done on a non-exclusive basis, however you so choose. All right, I'm going to keep moving in the interest of time. Let me know if you have questions on all of that. Final thing for copyright that we're going to cover, because I have a little bit longer on trademarks, is this concept of fair use. And this is something that particularly in the artist world, lots of folks have heard about. And fair use within the Federal Copyright Act, you are allowed to use someone's copyrighted work if it constitutes a fair use of the work. And so I'm going to read to you kind of the legal language in the statute. Notwithstanding the provisions, section 106, 106A, which are basically the provisions which grant you the copyright. The fair use of a copyrighted work, including such use by reproduction in copies or phonorecords, or by any other means specified by that section, for purposes such as criticism, comment, news, reporting, teaching, including multiple copies for classroom use, scholarship, or research, is not an infringement on copyright. Okay. So then, what the heck does that mean? Spoiler alert, nobody knows. Here are the factors, here are the main factors that courts use in determining whether your use of someone else's copyrighted work constitutes a fair use. The first is the purpose and the character of the use, including whether the use is of a commercial nature or nonprofit or educational purposes. This is a big one. Courts rely heavily on this. Are you profiting off someone else's work? That's a big factor. The nature of the copyrighted work, what does that mean? I don't even know. The amount and substantiality of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the potential market for or the value of the copyrighted work. So when I present to artist groups, I actually have quite a few slides dedicated to going through different court decisions, and I kind of have a game where they guess if the court determined whether a use was fair use or not. And this is essentially to show that it's all over the map. No court, there's no set standard on how much, how little, what purpose is gonna land you in that fair use category. So it's best to avoid, if at all possible. And if somebody tells you this is definitely a fair use, you're totally fine. Run away from that person. That is not true. Okay. And just kind of a quick example of ways that folks get themselves in trouble inadvertently. This comes up a lot. There are actually bots, internet bots, that large companies use to kind of troll the internet to look for infringements of copyright. And one of the big ones is Getty Images will do this. So we've had a lot of clients that get letters in the mail saying, maybe they've, gone on Google and on their website or social media or whatever, have pulled an image, don't think anything of it, use it. And then they get a cease and desist letter, not only saying, hey, stop using this image, but you owe us $1,000. Folks come to us and, we do a whole analysis on, is there actually a copyright associated with it? And can they prove any damages? And oftentimes, if we send a response, they'll go away, not always, but it's a good lesson. You can't just pull images off the internet without a license. So like, for example, the Getty Images, you need a license to use that work. And you can go and you can pay those license fees. So, okay, I'm doing okay on time. Is there any, Elaine, are there any questions in the chat that I can't see?
Kate, no questions at this time.
Okay. Okay. So, and don't be shy. Feel free to chime in if you have any. So we're going to go on to trademarks. If I can get my screen to work. There we go. All right. So the bulk of my intellectual property practice is actually in trademarks. Copyrights comes up less often in York County. So what is a trademark? A trademark is a word, name, symbol, device, or any combination used by a person to identify or distinguish goods of such person, including a unique product from those manufactured or sold by others. So you are distinguishing yourself in the market for goods or services from your competitors. Can also apply to nonprofits. It's not just for profit. So how's that different from a trade name? A trade name is simply any name used by a person to identify a business or vocation of such person. Trade names, and this is extremely important. A trade name, often called a DBA or a fictitious name, does not grant any rights to an individual to exclude others from using it. So if you go to the Department of State and you register the name ABC Company, okay, as a fictitious name or a doing business as, that grants you absolutely no rights. Essentially, you are just identifying to the state that you, Mr. Smith, are operating a business under this name. And it also allows the public to go in and identify who they're doing business with if it's a trade name. So it doesn't even stop anyone from registering an LLC with the Commonwealth of Pennsylvania or a corporation with that same name. So that is a huge misconception that somehow if you go and you register a doing business as name, that you have some rights to it, and you do not. Similarly, for an LLC or a corporation, let's say you register ABC LLC. The only rights you're really granted with that is that no one else can register a partnership, LLC, or corporation with that exact name. They can do small variations of it. Even if it's very confusing, the state won't stop them from doing that. The purpose of name registration there is not the same as trademark registration. So just consider that as you're registering. You're not really getting additional rights from that. Okay. Oh. I might be, there we go. I often get asked, what's the difference between a trademark and a service mark? Essentially nothing. It's just that trademarks identify, goods, and service marks identify services. To be totally frank, in the industry, most people just refer to all different types of trademarks or just marks. So what makes a good trademark? It must be distinctive. And this is very important when you're brainstorming your brand. Because the trademark law will only protect distinctive marks. And they are categorized into varying degrees of distinctiveness. The best being fanciful, followed by arbitrary, suggestive, descriptive, and generic. So what are examples of those? Fanciful being the best is essentially something that's just totally made up, not associated. Famous example, again, potentially dating myself for any younger folks on here, is Kodak for the camera and film. It's totally made up word, has nothing to do with anything. That is a very, very protectable trademark. It's often also why you see with pharmaceutical drugs, they're just totally made up because they don't want to fight about it. They just want to have protection of that name. The next is arbitrary. Famous example of that would be Apple. Apple products, Cell phones have nothing to do with fruit, and therefore it's arbitrary. The association isn't strong. Also a very protectable mark. You're going down to suggestive and descriptive. They're kind of in the same category. It's when you're suggesting what you're doing or describing what you're doing. So Bob's Best Bagels. It's not that protectable. There's a lot of Bob's. There's a lot of bagel shops. So you're getting into territory where you might get some level of protection, but potentially not. And then generic. Generic is absolutely not protectable. It's just a term that is describing exactly what it is. All right. Okay, what's the difference between the types of trademarks, state, federal, and common law? There are also international marks. I don't practice in that area, so we're sticking within the United States. Federal trademarks, let me just check my time. Okay. Federal trademarks are marks that are issued by the United States federal government, and they grant the owner rights to enforce their mark throughout the United States. It's a huge amount of power you have if you are granted a federal trademark. And as a result of that, it's very difficult to get. And we'll talk about some of the complications with getting one, but the process can be expensive and long. It generally at a minimum takes 6 months to obtain. Since COVID, I've seen that grow to significantly longer. State trademarks are marks that are issued by the state, and they grant the owner rights to enforce their marks within state boundaries. Kind of useless, and I'll describe why in a minute. For example, here in York County, we're a hop, skip, and a jump away from Maryland. So, you know, having your rights stop at, you know, Southern York County boundary line is not super useful, particularly when you know that common law rights exist for a mark. Common law rights exist similar to copyright the moment that you start using a mark, so a logo, a name, in conjunction with goods and services. So even if you don't register anything and you have a logo associated with your business, you're going to have rights to that mark within the geographic region that you use it. So if you have a car wash in York County and you have a certain name for a car wash, and somebody else goes down the street, and you're known for how good your car wash is. Someone else goes down the street and tries to open a car wash with the same name or something really close to try to get your customers away from you. You still, even if you don't have a federal copyright, have the ability to enforce your rights. It can be more difficult because you don't have a piece of paper showing I own these rights and here's when they started. So you have to prove, you know, that you were first to use it, what your damages were, all of that. But you do have rights simply by using the mark. All right. What's the trademark standard? And this is very important, both for if you ever are charged with infringing someone or if you're trying to obtain a mark. So the standard for whether one mark is infringing on another is whether consumers are likely to be confused by the two marks. So it's important to remember that this standard is to protect consumers, not business owners. So the idea being that a consumer should be able to go to a store and be able to know the source of the product or services that they're getting. So everything that stems from trademark infringement really has the eye on protecting consumers, less on protecting businesses. And we'll get into that in a minute. All right. I see a bunch of things coming in on the chat, so I will make sure to not go too long so we have time for questions. All right. We're going to send this around. These are the standards for trademark infringement. There's a whole bunch. There are, let's see, 13 factors that courts will use to determine if two marks are infringing on each other. So I won't go through this. And and we'll send around the presentation. So I put this slide in specifically for this because this is something that's coming up in York County quite a bit. We have businesses that have been doing business in York County for many years, sometimes decades, under certain names or logos, and all of a sudden they get a cease and desist letter from California or whatever, saying, you know, here's my federal registration of this mark. You don't have a federal registration. You must stop using it. And the analysis immediately goes to, did the client have prior use of the mark? So there's a quirk in trademark law that even if you have a federal registration, that does not, you do not have the ability to stop others that were using that mark prior to your registration. So somebody can go and register it if you don't have a federal copyright. The trademark office isn't going to necessarily stop them if there's no registration, but they cannot then later in time, if you started use beforehand, come back and say, hey, I know you've been using this for decades, but I registered a trademark last week, so you're done. The problem with that, though, as the individual or the company that does not own the trademark, is once someone else registers a federal trademark under that name or logo, you will then be frozen in the territory where you were using the mark at the time of that person's registration or company's registration. So if you were only in your county, that's it. You're only able to use that mark within your county. The federal registrant has rights everywhere else. So you won't be able to grow or expand. So it's one thing to think about on whether going through the cost and expense of getting a trademark is beneficial. And we just went through this. It's largely, I didn't mention this, it's largely because of the global economy. So, you know, brick and mortar York County businesses that never had an internet or social media presence for decades didn't bother someone out in California, but now everyone, you know, has a social media or website presence, and it's creating more friction. And we went through this. As I indicated, you need to verify whether the person telling you to stop using the mark actually holds a federal trademark. You need to determine whether their mark is actually confusingly similar. And this is an analysis that partially is those 13 factors, but other things. There's various standards that the trademark office will use and federal courts will use. It's not simply, is it exactly the same? It's which word comes first, are the colors the same, all different types of analysis. And you may need legal assistance. It's not necessarily something that the naked eye can determine. And then finally, confirm the first user of the trademark. So if you're a York County business that started using a mark in 1990 and a federal registrant that registered in 2021 comes along, they cannot stop you from continuing to use your mark. All right. Potential roadblocks to registration. So maybe, you know, you've started your business and you're like, you know what, it's worth it to go forward with federal registration. What can happen in that process? As I indicated, it's about a 6-month process. If you come to a lawyer's office, we do, or at least I do, a nationwide search to determine other marks that are out there, not just in the federal database, but state databases and common law marks. So if you're starting your business, you don't want to, you know, pour a ton of money into marketing and branding materials only to find out that someone else has something similar and is going to send you a cease and desist letter that you have to abide by. So once we complete that search project process, we say, all right, maybe you can go forward. There are potential roadblocks. So one would be an existing prior federal mark, and this would be discovered in the search process. We would tell you not to go forward. And this kind of coincides with number 3 I have here, the 2D refusal by the Trademark Office. That's a famous refusal, and it basically is that confusingly similar standard. So maybe a federal registrant doesn't have your exact copyright, or it's not exactly the same goods and services. A trademark examiner can go in and say, nope, it's too close, we're going to reject you. And these are humans with subjective standards. So they do look at prior decisions, but the standards can be quite subjective. Going back up, a challenge during the publication period. So kind of going back to the process. Once you submit your trademark application, a federal examiner will pick it up after 2 or 3 months of it sitting in no man's land. And let's say they approve it for registration. After that, there is a 2-month publication period whereby anyone in the world can challenge your mark. And this is also important on why the search is important, because if you have a big name that owns something a little bit similar, like a Procter and Gamble, Walmart, something like that, you know, that have, you know, so much money to throw at you, you might want to think about changing your name or not going forward with registration to alert them to the possibility. Because there are folks that sit all day, every day and look at the trademark registrar publication to determine if there are any infringing marks out there. So that can happen, and you can be caught up in all kinds of litigation. Generic nature of the mark, we already discussed this, but kind of in conjunction with that, the use of a geographic term or surname. So the Trademark Office kind of identifies geographic terms like York County as inherently generic. It can be part of a trademark, but it makes it less likely to be registered. And surname, you know, the Trademark Office doesn't want people to have the ability to go and register folks' last names and that they can't then use their last name. So that's kind of an automatic no. And finally, this one's an interesting one. If the mark has an ornamental character, so like a pattern, the Trademark Office doesn't want to register patterns because they feel that it's merely ornamental and not identifying a brand. Okay. And just also quickly, I wanted to give an example of other reasons recently that long-term York County businesses have decided that federal registration of trademark is important. And that's one, because of online sales. Major platforms like Amazon will not enforce or assist you to enforce infringement of your mark unless you can prove you have a federal trademark. So we have instances, particularly on Amazon, where you might have a product, a long-standing product, and part of your sales are through Amazon. And in China or other countries, there's a large market of, you know, intellectual property piracy, whereby, you know, they're literally purposefully trading off of your brand. We have found that Amazon will not, even though it's very clear that they are trying to trade off of a legitimate brand, Amazon will not stop it unless you can prove that you have a federal mark. So that could become difficult if you're a longstanding business and you're like, all right, I guess I got to do this now. What happens, and this has happened to some of our clients, you know, they've been in business for many, many years, and they want to register their mark, and guess what? There's somebody out in California or Arizona that has something that's too similar, and they can't get the federal mark, even though they have been in business for decades. You know, it's a pickle. It's a real pickle. So, about 5 minutes. That's good, because this is my last slide. Searching federal trademarks. So let's say you're in the brainstorming session or portion of developing your business plan. You want to see what else is out there. You know, see if someone else has already had this idea. And Google is your best friend, just starting there, see what else is out there. You know, even if it's not an exact match, if there are a lot of similar businesses with that name, maybe back to the drawing board. But what I have here is another tool. This is the test system, the Trademark electronic search system. And there are various degrees. They have kind of the beginner all the way to advanced searching, where you can go on as the public, it's totally free, and search to see what types of other federal marks are out there. So I have a caution here. So let's say you type in your exact mark, the words of it, and nothing comes up. That's not necessarily sufficient to show you that there's nothing out there. That's why we do a nationwide search, and we actually pay a third-party provider to go out and do various combinations of searches to pull up not only exact matches, but things that are similar within the same product or service range. This also won't help you if someone has a state mark, and maybe it's a closed state mark, maybe it's in Maryland or a common law mark. But it is a really good tool, particularly in the brainstorming session, you know, to, you know, realize how many marks there are out there, and will help you maybe save yourself some money in the future by having something that's truly original, or hopefully totally fanciful, that is very protectable at the trademark office. So I know there's a lot of questions, so I'm going to go ahead and stop there. Here's my information if anyone wants to copy it down. Before we take questions, I did want to let you know that if anybody has intellectual property needs that is on this webinar, feel free to email me. If you're a part of this webinar, we're going to offer a 10% discount on that work. So just let me know that you were here, and we'll be happy to take care of you. So we can do questions now.
Thanks, Kate. That was just really a tremendous amount of great information. And you know what I took away from that? Many things, but one thing that my accountant has told me, and you have said, it's less expensive to start out the right way than to try to clean up a mess after the fact. I don't know if you would agree with that in this case, but certainly you have given us information to help us avoid some pitfalls here. And so I hope that everyone who's joining in has found the information valuable. We have lots of questions, so let's get into those, and there are more coming in. So to be fair, I'm going to start at the top of the queue and work my way down. Is there a time limit on my trademark? How long is it valid?
No, there's no time limit. However, there are maintenance requirements. So if you have a trademark, you need to file renewals with the trademark office, first in between year 5 and 6, and then at year 10, and then every 10 years after. And not only that, you have to prove that you're still using it. So you have to provide what's known as a specimen to show that you're still using it.
And when you say a specimen, that could be something as simple as like a brochure or
the label on your product, website. Yep.
Mm-hmm. Okay. And this is something that's come up in our work when we rebranded for Downtown Inc. with Historically Edgy. And the question is, if I receive a copyright, should I include the C symbol on my work, and when?
I talked about this a little bit. You don't have to, but you can, and it identifies some level of ownership. It's kind of more of a deterrent than anything legal, but to actually deter folks from thinking about an infringement, it's not a terrible idea.
Okay. And I think I know where this question is coming from, but I'll read it to you first and we can discuss. For the restaurant and hospitality industry, how can I use a trademark and copyright? So, sometimes you see restaurants pop up and their names are, taqueria. And so what would your recommendation be for restaurants for their name brand, and also anything that's like trade, can it be trademark or copyright in terms of recipes or signature dishes?
Um, Again, so for the recipes, you could potentially be in more of a trade secret realm again. So keeping those recipes a secret, that's actually, I referenced the Coca-Cola recipe. So there's likely a lot more protection in keeping that information secret, not making it public, than there would be in any sort of copyright. You know, I guess technically you could copyright the, physical copy of a recipe, but I don't know if you can stop folks from doing the recipe.
Something, having the same dish named on their menu.
Yeah, and as far as names of restaurants, it's kind of the same as regular businesses. The more arbitrary the name is, the more protectable it is. So the more you're describing what you're doing, the less protection you have, and the more competitors for the name you'll have.
Okay. Let's see here. For the retail business, how could they use trademark or copyright? I think we covered that, but I'm not sure if there's any more depth of if you're let's say, an apparel retailer or vintage consignor. Is
I
there
mean,
any additional consideration?
potentially, you might be working, it's probably more trademark. You might be looking to trademark more than just the name of your company. Maybe there are certain designs that are important to you or to the business that on top of the name of your business, you want to trademark. So think about like Nike. Not only is Nike, the name, important, but that swoosh is highly important to Nike. They have trademarks on both.
Mm-hmm. Yes, that makes sense. Next question is, if I copyright a book, a novel, and a couple years later, I decide to use a pen name, do I need to go through the whole process again with that pen name?
Not necessarily. You as the individual will still own the copyright. Just because you use a pen name doesn't necessarily change the ownership. I'm not sure if I'm answering that individual's question, but the ownership doesn't change regardless of if you're using a pen name or not.
Okay, so it sounds as if the ownership stays with the individual regardless of the name so that it almost is a line of connection to that individual regardless of what, okay, I think that makes sense. Hopefully that makes sense to the person who asked the question. This is an interesting one. How does a trademark differ from a patent?
Yeah, this is big. So a patent covers inventions. So a change in a product or a new product or anything like that is covered under patent law. And patent law is very niche. It's very specific. You actually need to take a separate bar exam to practice before the patent board. And most individuals that practice in patent law have science backgrounds to go through the complexities with that. So I don't practice in patents, but if anybody has invention or invention questions, feel free to email me. I have a lot of folks I can refer you to that can assist you with that.
Yes, and just a reminder that Kate's email is in the chat. It's kh@stockandleader, all spelled out.com if you want to reach out to her. Okay, we have a few more questions and then we'll be rounding out our time. These are all from the same person, so I'm going to read through them. I think there is some interrelatedness here. First one, this is one I haven't even thought about. How do you research trademark colors and smells? I understand TESS acronyms, but not that.
That is very difficult. That is something that I have not, to be totally frank, come across in my practice in York County, but the the person who asked the question is right. You can trademark colors. You can trademark smells. For example, I believe the Tiffany blue color is trademarked. But there is not a good system that you as an individual can use that I am aware of to search for that. What you can do is you can hire companies like we do when we do a search. And if you're looking at colors and smells, it could be quite pricey for them to go and assist you. And if you have questions about what those services are, I'd be happy, send me an email. I'd be happy to refer you to them.
Okay, great. Yeah, I forgot about Tiffany Blue. Yes.
Yeah.
Great. Okay. Another question. Also, and this is specific to when you talked about a name being fanciful, arbitrary, do you think Zeer, Z-E-E-R, is fanciful? It's a medieval form of Arab refrigeration, and some rare people use it as a last name. So
I guess the question would be, are you using it in connection with refrigeration? Because so I'll just answer, presuming they are. In that case,
he's saying no, he's not
Oh.
using it as, he's not using it. He's just explaining the definition,
Okay.
looking at the chat as we're talking. So
Yeah, I think it's probably, since it's a word that actually exists, it sounds like in another language, that doesn't necessarily count as fanciful. It's probably arbitrary because it sounds like from your answer that it is not, corresponding with the goods or services. So oftentimes you do have to identify that it's not identifying a specific person when you do the application. So if it's not, it's probably okay.
okay, great. And last question, and this is also from the same person, do we need separate applications for name and logo? Which is best to do first, the name or the logo?
The answer is yes. There are different types of applications. The name can be under what's called a standard character application. So it's basically just the name with no design, and the logo would be under a design mark application. Lots of companies register both, and there's no right answer. It kind of depends on what's more important to you. Is the logo the most important, or is the name, as it's used in a variety of forms, the most important?
Okay, that's good to know. But to your point, it is two separate applications.
It is, yes.
Yes. And if I can just add on to that, and this is the last question. I know I keep saying the last question, but one more. If you establish a brand and then say you go through rebranding, companies do that as they grow and evolve, and then they change what their logo looks like. You need to resubmit that new logo. Is that correct?
Yes.
If it's very different. Okay.
Correct. Also, really quick on that, let's say you are under the same name, but you expand your products. You'll need to do an application to cover those products. They do not automatically go under your mark.
Ah, important information. Well, Kate, we're at the end of our time. I think this is probably the fastest workshop, but I learned so much, and I hope all of you did as well. I am just so appreciative to you. As I said at the beginning, Kate, you know I love having you on my team. I love having you as just a resource right here in York County, in the heart of York City. So I encourage all of you to please watch the replay. If you missed anything, reach out to Kate if you'd like to connect with her or someone at her firm, or just, as she said, so that she can help you make those really smart decisions for yourself as a creative, as an artist, as a business, so that you can continue to grow and thrive. So last thing I will say before we wrap up is please save the date for the next business series. We have more great information coming up. August 18th, we're going to be talking about public safety. We have some great presenters lined up for that as well. And then First Friday, yay, First Friday is coming up, August 6th. So join us for First Friday. You can find out information about what's happening all around downtown on downtownyorkpa.com. And if you're a business or an organization that has something fun happening for First Fridays, we want to know, we would love to promote it. Just email us at info@downtownyorkpa.com. Thank you, everybody, for joining us this morning. Thank you, Kate, for the fantastic presentation. To PNC, our presenting sponsor. Everybody have an awesome day. We'll see you soon. Bye-bye.
Thanks, everyone.